Court of Appeals Division 1 is now in session.
Thank you. You may be seated. Good morning. We are here for oral argument in our case number CV23-0669, Weber versus Weber. I am Judge Ferruia, and to my right is Judge Morse, and to my left is Judge Weinsweig. And as you may know, we record and live stream these proceedings, so please give your name and the name of your client when you begin. You will have a maximum of 20 minutes per side, although you are not required to use all of that time. We do require that you keep track of your own time, and the clocks in the podium are there to reflect your total remaining minutes. That includes any time that you would like to reserve. You are responsible for reserving that time. Please keep in mind that we have read the briefing, we have studied the record, and discussed the case in conference. For any who are here in observing, we would counsel you to make sure that your phones are on silent to prevent any embarrassment. And with that, you may proceed, counsel.
Good morning. Michael Ellsworth on behalf of the appellant, Justin Weber. I feel a little bit this morning like we're trying to drink a little bit out of a fire hose with the number of issues that have been raised, so I'm going to try to use my time obviously wisely and limit that. As noted in the response brief and then in the reply, initially the assertion that was made on behalf of my client of the presumption of a 50-50 schedule, obviously that is not there based on the case law. But I would like to just briefly read a few of the court's statements from the three cases that have been discussed. First one is Barron. That's the 2018 case where it says first, in that case, first the court legally erred by applying a presumption against equal parenting time. So it's funny that presumption word comes out again that we don't find in the statute. But nearly all the court's findings disregard the statute's starting point, which is that when consistent with the child's best interest, each party parent time would be maximized. Barron goes on to continue to state that equal parenting plan would not allow for her and mom to maximize a stable maternal influence. In that case, just as in this one, the judge looked at the past history of the parenting schedule and the parents being together and father in this case working, mother being at home, and used that really as a basis of saying here's how we're going to continue the parenting time. Barron goes on to state the court erred by favoring parenting time for a wife or husband based on the fact that the wife had been the child's primary caregiver during the marriage. Whether one or the other parent was a primary caregiver during the marriage used to be a factor, but is no longer a factor that is considered. Barron goes on to state, dissolution necessarily will disrupt the family dynamics. Whenever one parent has been the primary earner while the other has stayed home to care for the children, upon dissolution, and this is where the trial court, I believe, erred in making a ruling, was the wage earner usually must find child care, and in our case, the judge determined that father's work schedule would not allow him to exercise more parenting time, and the stay-at-home parent must find work. And again, in this case, the judge determined, well, because you've been the stay-at-home mom, because you have been homeschooling, I'm not going to even impute you at income, which we'll discuss here in a little bit. Then we go on to the Wotan case in 2019, where the issue about the presumption comes up. But it's note, in that case, the court shall adopt a parenting plan that maximizes the parent's respective parenting time. And when we look at what the judge did here, we go back to actually temporary orders. On a temporary order, the judge gave father, Justin, 4 days a month two weekends from Friday until Sunday. Then we come into a final hearing, and the judge, and I had noted in our opening brief, the judge made some erroneous findings in this case. One of those was the judge had noted in her ruling that she attempted to give father additional parenting time on weekends at the end of the trial, and father couldn't because of his work schedule. But if we look at the transcript, what was said was, Judge, we're starting summer. You've only had dad at 4 days per month. Can you give dad some extra parenting time? And it was testified to at the trial that dad was working in every other week schedule. So then the judge said, well, I'll just give you every weekend. So the response to that was, Judge, father can't do every week. Excuse me, he was going to give that the judge was going to give father every weekend. It was then responded, he can't do every weekend because he has to work every other weekend. So then the judge says in the decree, I tried to give father more time and he couldn't take it because of his work schedule.
Counsel, if you accept that there was some conflicting evidence presented and we really aren't in a position to reweigh or make credibility determinations, et cetera, what is lacking in the fact that the court, considering the homeschooling, the court's decision that it wasn't comfortable allowing grandmother to be the caregiver during father's parenting time unsupervised, and father's acknowledged work schedule with what's basically a 2-to-1, but 140 days a year parenting schedule? I mean, what could we point to as a matter of law and say this was an abuse of discretion? Not whether we think the court got it wrong, but as a matter of law, the court cannot do this.
Well, in part because of her erroneous findings. And we can always say, well, that it didn't really affect the case, but she made erroneous findings in getting to her best interest determination. One of those was, hey, Dad, you can't do it because of your work schedule. But we look, why couldn't, if we're trying to maximize Dad's time, could he not have parenting time after he gets off work? Mom can still homeschool, and Dad gets to spend time with his kids 7 nights every other week in the summertime. And that's kind of what I was referring to, is the judge said, well, I can't give you more time in the summer.
Did you propose nighttime schedule during the trial?
We did. We said week on, week off. With that, the father's work schedule.
No. I want to make sure my question was clear. Did you propose this week on, week off, but we'll just do evenings, you do daytime?
We did not. Because if we look at the language that we talked about in Barrett, what was it said? Father could get child care.
So you're saying we should fault the court then for not doing something that you didn't suggest?
I guess in a way we could look at that, what we're saying is the court erred in basically punish him for having a job.
Okay.
Is what the judge did. And that actually came out in that conversation with the judge at the end when we're talking about this additional parenting time. But it's funny because the judge said Dad didn't take any more parenting time because of work schedule. But if we actually look at the transcript, the judge gave him, after we had a discussion with the court of, Judge, he has these extra days, the judge actually gave him a Thursday and through Monday. So when the judge erred in her findings of saying he didn't take extra time because the judge gave him extra time. That's just one example. Another one where the judge, in this case, made erroneous findings was this issue about father saying that there was inappropriate behavior with the granddad. And the judge in here twice, in her ruling, relied on that as part of her best interest, and then even throws in, well, he's a mandatory reporter. The language in on page 114 of the transcript, Dad was asked, was there an issue with her dad, something that was going on with the kids that you brought up to her? Yes, there was. The number, and one of those being the youngest daughter would go into his room and he would close the door. And I talked to her about it, of just saying I don't think needs to spend a lot of time in there. And Mom agreed. Where in the transcript? That was the only time that was talked about. Yet we get the trial judge who says Dad alleged that there was inappropriate behavior with Granddad, and if he really thought that, he should have reported it. That's another erroneous finding, but she relies on it twice in this ruling. And
she
doesn't
notes
give.
it. Saying that she relies on it is a bit of a inference that I'm not sure I follow.
Page 5, paragraph 6 of her ruling, the court finds there's no credible proof that mother's father was inappropriate with any of the minor children. Father is a doctor, is a mandatory reporter. Court finds father intentionally misled to persuade the court to give parenting time preference to father. So I would suggest she did rely on that, because she actually made a finding that he intentionally misled.
Okay, but as a basis for, how does that fact, how do we say that the court then relied on that in deciding how much time to give father?
Because the court went in and, pursuant to CR 25403, weighed the factors. And again, we're saying the court made erroneous findings in that being one of them, of the erroneous findings. And then the court used that to come in and say, okay, based on the best interest of the children, I'm not going to give 50-50. And we'll acknowledge a lot of that had to do with the homeschool issue.
And his work schedule.
And his work schedule. But what he testified to and what he was doing at that time, he was doing a week-on, week-off work schedule. And what the judge did in taking and not giving more of a 50-50 schedule, I mean, father's a doctor. He's a physician. Mm-hmm. He couldn't do homeschool with the kids. The judge also made an erroneous finding.
Counsel, is there evidence in the record that father has homeschooled before, that he had done any of that kind of groundwork?
There was conflicting testimony about father's involvement. He testified, yeah, I do things with the kids. We do things together. We do math. We read. Mother suggested something else. So
Okay.
There was conflicting testimony with that.
And our standard of review is?
Right, that we rely on the judge who's in the best position to make that finding based on the evidence.
So help me understand how we get to where you are asking us to go when that's our standard.
Because of because of the judge's erroneous findings on other issues.
Okay, so you're talking about this thing over here bleeding into this over here, and that has poisoned the well. Is that, am I understanding that correctly?
If we look and I know this isn't the case, and I know judges, Superior Court judges have a lot of cases, they have a difficult job. But if we were looking at somebody who is testifying at a hearing, and they're not credible on 3 or 4 issues, does that not bring into the issue of potentially credibility on other things? So when we have the judge that just clearly makes findings that are contrary to the evidence.
So what you're arguing, because I'm not presuming to put words in your mouth, but what I understand you saying is that because we have this one issue over here which involved a credibility finding or explained the judge's weighing of father's testimony, that has poisoned everything such that it needs to be overturned. Is that a fair?
It is. I wouldn't say everything, because there are some things that are based on the record that are factual. But when ARS 2543, when we have to weigh those factors, which a trial court judge does, and then the judge on 3 or 4 of those factors makes erroneous findings, then it really suggests, and it looks like, and I would state that it does, that the judge made a decision based on error in her own findings.
Let me ask you, counsel, let's assume you're right, that there was this one error, but there's still reasonable evidence to support the trial court's parenting time conclusion. What would we do with that?
Okay. Well, I would suggest that if we look at the record, there really isn't a whole lot to support that.
Well, you had said, I think, work schedule and school. Just now,
Well,
you said they applied the factors, and so before we talk about whether or not that's reasonable evidence, I just want to hear from you. Even if she made that mistake, if there was reasonable evidence in the record, what does this court have to do?
Okay. That in looking at the evidence, and we say reasonable, if we look at all the factors, and there may be, again, there are certain factors where that the court's finding was factual, like the work schedule. Dad does have to work. But that's where it's, again, Barron case was working parents have to go find child care providers. Other parents who are stay-at-home moms or dads have to go find jobs. So another error that the judge made in a finding, for example, is with Benson, stating that he has these medical needs that requires mom to be at home and to be able to manage those. Her own testimony was there's been surgeries in the past.
So, counsel, let's forget about this case for 1 second. If there's reasonable evidence, as that's defined under the law, and we have this one mistake still, what does this court must do?
Yeah.
It's a simple question.
Is that one, I don't believe there's reasonable evidence.
What is,
What does this court do?
and that's not what I'm
Okay, I
saying.
understand.
If there's reasonable evidence, and we still have this one error of fact, what does this court must do? What do we
You would have to affirm the court's ruling on that issue.
Okay, and now, why isn't there reasonable evidence other than this one issue of fact that you're talking about?
And there's not just one issue. That is one. Another one is Benson.
I'm going to write them all down.
Thank you. One is the fact that the one we just referred to, Benson, the minor child that has a cleft palate. Mother's own testimony was, from the record, he's had surgeries.
Counsel, please don't use the child's name.
I'm sorry. That he's had surgeries. And in the future, for the next 6 months, he has to go one visit down to the doctor. That was all that was in the record as to any special needs this child would have.
But
But
that
yet
is a need.
It is a need. But the judge made it so significant, the mother has to continue to stay home and homeschool this child. So
Isn't that a weight issue, though? I mean, it is evidence, and you're asking us to say that it wasn't as weighty as the court determined, which is much my opinion of the earlier evidence about the grandfather's testimony. The court was in the position to sit there and make her evaluation, or his evaluation, I can't remember, of what he intended by bringing that up. How do we say that's a really erroneous decision as a matter of law?
I would say because based on what was said and was testified to, those facts in the record don't support that.
Counsel, if I could direct you to address the debt issue.
You bet.
So the loan. So could you?
Yes, so there was the evidence presented, and it was suggested that there was no evidence presented as to what that amount was. And I believe it was exhibit, 38 that was admitted, and I believe also maybe exhibit 6, that there was testimony and exhibits admitted that father had incurred student loans. There was an exhibit that was admitted showing what the actual cost of tuition and the education was. And then there was testimony that the additional amount of about $274,000 was for living expenses. And over a period of 5 years, which he took for medical school, that'd be a little under $60,000 per year for living expenses. Mother did not dispute that there was living expenses that were incurred. Mother did not dispute that student loans were used for those. But then we have the trial judge who said, I'm not going to divide that debt. Husband, you're going to take all of it. And by the way, and she also notes, I believe the trial judge says, well, he's getting the benefit, obviously, of the degree, but also isn't mom and the kids getting the benefit of the degree? Mom's getting the benefit of that education because he's paying spousal maintenance. He's paying child support.
The court seemed to rely on the fact that their mother's testimony, and I'm fully crediting the court's determination as to credibility, that there was some pre-community debt included in that total. What do we do with that?
Well, and it was noted, and there was an objection to that. Mother never raised the issue in a pretrial. Mother never presented any evidence.
Not procedurally. Let's say the court was right. She believes mother's testimony was right. There was some pre-community debt. Why does that make the whole debt suddenly sole?
Well, why does that make that whole debt sole?
Yeah.
Well, I would agree it doesn't. It's still community debt. The judge could have had analysis, hey, I want to know what was pre-community and what was post-community.
Is your client, can we fault you or your client for not providing the more records in some way?
I would say no.
That how much debt and when that was incurred, et cetera?
I would say no, because we did provide evidence of what he was saying it was. And again, there was nothing in a pretrial statement or any other exhibits, any from them saying, hey, this is inaccurate.
To let you know you need to provide more.
Yeah, so we didn't have a chance to dispute that, but we didn't need to because we thought we had what was there, what needed to be done with that.
And she certainly acknowledged that at least some portion of this debt We don't know exactly how, but at least some portion was taken out during the community.
Correct. And then we have the trial court's erroneous finding, too, that this is going to be somehow forgiven into the future. There was no testimony. The testimony was this will not, or I do not have this option at this point.
But
And
he
that-
acknowledged that it's a possibility.
He did, but that's what I put in our response.
If you want to reserve time, we're down to a minute.
I'll go ahead and take the little bit because probably a minute and a half is not going to do me a lot of good at the end. But as stated in our briefs is that if in the future there was loan forgiveness, the mother would get the benefit of that also.
Yeah.
So
If the court divided the debt, you would and it was later forgiven, you would certainly not oppose any type of motion to modify that allocated that forgiveness among both parties, right?
absolutely not, because that'd be fair and equitable. Last little thing, again, I've got about 50 seconds, is this issue of imputing income for mother. There was a vocational expert that would testify at trial that because of her education training and past work history, she was capable of making anywhere between $50,000 to $60,000, and that could be either remotely or it could be an in-office type job. And the judge just totally disregarded that, and the judge used the homeschool as stating, well, because she's homeschooling, I'm not going to impute her to anything. At a minimum, the judge could have said, well, look, dad is having 130, 140 days. I'm at least going to put mom at some part-time employment. She can go work on those days when dad has parenting time. But she totally disregarded any of that.
Did you suggest that affirmatively?
That little portion, no, because we were saying dad can watch the kids and mom can go work.
But you didn't say as an alternative, she should work at least during father's visitation time.
No, but I did ask her if there was a 50-50 schedule, if she could go work, and she said yes.
Okay.
She acknowledged that. Thank you for your time today.
Mr. Shields.
Good morning. May it please the court. Mark Shields, just for today, on behalf of Christina Weber, at council table is Brad Kreider, who authored the answering brief. This case, as I believe this court has already seen, is all about a judge's discretion. That must be kept in mind throughout every argument. Now, when a client comes to me asking about an appeal, I typically describe the appellate process by using a football analogy. I talk about goalposts. I say, ideally, you want the ball to be kicked right in the middle of the goalpost. You want it to be kicked so hard that it goes into the stands and somebody gets a souvenir. But in reality, as this court views a record, as long as that kick goes anywhere in between the goalposts, it still counts. It doesn't matter if it's an ugly kick. It doesn't matter if it squabbles from side to side. It doesn't even matter if someone gets a hand on it in the way. As long as it clears those goalposts, it's good. Now, in this particular case,
Would you agree we should do our best to construe the court's ruling as fitting within those goalposts?
I don't believe it's necessary, actually, and I would like to explain why. Because in a case like this, where we're dealing primarily with parenting orders, those goalposts get extremely wide. As long as the 403 findings are made, and as long as the trial court doesn't clearly deviate from those or didn't mess up with them as it did in the Barron case, those goalposts are very wide. Not only that, they're very low. They go almost all the way to the ground. We're not dealing with a situation like that where there are some findings that are made that are contrary to, for example, the Equal Protection Clause as noted in Barron. Therefore, just about any kick on this record is going to clear. I don't believe the court has to look at it one way or another other than to acknowledge what this court has acknowledged time and time again.
Let's talk about decision-making, because it seems to me there is we need to define those goalposts a little bit.
Okay. Looking specifically his argument about the presumptive versus final, I don't know if that's specifically what the court's referring to.
So I was on a case a long time ago called Atkinson, which you guys cite.
Yes.
And I was also on the case at the lower court, or here, before the Supreme Court smacked me around and told us we were dead wrong. So I've got a little bit of history with this issue, and it's possible that when Atkinson came around, I was still smarting so much from the case that I just didn't even give it the proper thought or reflection that maybe it deserved. But in reading the case now, it and the statute both say specified.
Thank you.
What has been specified in this court's ruling?
What has been specified is that it would apply to decisions that are disputed between the two parties. Now, admittedly,
Doesn't that mean nothing?
No, and I'd like to
So in
explain
other words,
why.
we'll give you joint decision-making until you disagree, and then it becomes sole?
Well, actually, the way this is worded with presumptive, it is a hybrid, as the Supreme Court rubber stamped, as the Supreme Court approved, but it
I don't
actually...
think our Supreme Court ever just rubber stamped something. So.
I apologize, that was the wrong term to use. But when it is presumptive, as it is in this case, father actually has greater legal rights. And the reason why is because mother's decisions are subject to judicial review. If she had final decision-making,
No,
if she
it
had sole
actually is the opposite.
decision-making...
I think that by setting up this presumption that at least the way the court did it, it's saying, when you come back to us, instead of starting on equal footing, we're going to presume that mother was right, and that the burden is on father to prove that she was wrong.
And I believe that would be if, in a typical case where we would go back to the court, it would be for a modification. In this case, it is specific to parental decision, so he does, as I read it, have a right to judicial review for any significant decisions with which father disagrees.
Yeah, but if it was true joint, which the statute seems to contemplate, except for specified issues,
Correct?
it would say they can't decide. Both parties would have to go to court, one or the other, to get the other one to agree to the issue, and then the court would say, all right, let's look at it neutrally, but now we've got the opposite, don't we? And let me see if I can throw you a lifeline. So I was originally very concerned about the court's ruling here, and also concerned about my concurring in the decision in Atkinson previously. But then I reread the court's ruling, and it talks about parental decision-making, and then talks about if the decision involves medical or schooling issues, and then the next paragraph it says that it can't agree after making good faith effort to reach an agreement any such major issue. How do I read that other than that's actually saying that this presumption and this final say applies to medical or schooling issues?
That would be a reasonable interpretation of it, yes.
Okay.
But
So even if I think I'm wrong, I was wrong in Atkinson, I can say I can still affirm this because the most logical and natural reading of this is that the final presumptive decision-making is to medical or schooling issues.
that would be a reasonable reading, and this court is never under an obligation to, neither is the trial court.
I don't know what such
under an
means if it's-
obligation to-
What such means if it isn't saying limiting these major issues to medical and schooling.
And that, again, would be a reasonable interpretation of it. Perhaps the only reasonable interpretation I'm able to think of. For the record, I was involved in the
And
case
thank you for
also.
not telling me I was wrong in Atkinson, so that's nice of you.
I do have to take a few seconds to say that I spent years advocating in family court that this final decision-making didn't exist because it wasn't in Title 25. This court agreed with me. In the original version of that, I was involved in that case for a day. And then the Supreme Court said, no, we're allowed to hybridize it. What we have here is a hybridization, just as we had in Atkinson.
Counsel, let me ask you about, was there conflicting evidence in the record on whether father's undergraduate loans were rolled into the medical school
I
loans?
actually don't believe it's conflicting. I think it was acknowledged that they were. The conflicting evidence was how much.
Okay, so it
and there
was
uncertainty.
acknowledged as passive voice. Who acknowledged and where did they acknowledge?
I can't give the court a citation on the specific transcript number. Mr. Kreider may be able to work on that, but my reading of the evidence as cited in the answering brief is that that was acknowledged. There certainly is a finding for that. That was one of several findings on that subject.
Why does that, and it seemed to be very important to the court, and the court below, and I don't understand that. Why does it matter if some of it predated?
Oh, because that would clearly be his sole and separate, and they were
Right,
asking.
but it doesn't change the presumption is debt acquired during the community is community debt.
Okay, thank you for that question. We have needed case law on student loans for many years. I have advocated for this court to give us such case law. What I will say is this is not the case for this court to set precedent. That fact about premarital student loan debt being rolled into this is one of the reasons why. It did factor into the court's decision, and the court was justified in doing that. The biggest factor, I believe, is the loan forgiveness. The fact that it's going to be forgiven. Judge Morse, you said, well, if...
Hold on, counsel. Going to be forgiven presumes a couple of different things, one of which is continuance in public service. Is that not so?
It is, and I believe he's at about 7 years to go now.
Okay, so we have a 7-year horizon where this individual or father needs to continue to work for public service before he realizes that goal. But what compels him to complete that 7 years?
Nothing compels him, but presumably he will do that because there was testimony that that was the entire plan, and it was one of the reasons why he took this. That's one such reason. Again, it's part of the whole formula. The premarital debt, the lack of specificity about how much that debt was. I mean, basically, Dad is tasking the trial court with throwing a dart at a number and hoping that it's correct. It just isn't fair. And again, that's another reason why this is not the good case to submit precedent. The other fact is, this is true, that his degree is separate property. There's case law on that, and it's clear. Typically, the rule is, if you take the asset, you take the debt that goes with it, and that's the student loan.
Play devil's advocate here. I was impressed, I don't know if that's the right word, but I thought it was eminently reasonable that father seemed to acknowledge the tuition aspect of it I'm on the hook for, because it's my degree, et cetera. I'm only asking for a portion of this loan that was used for family living expenses. Arguably, especially since he's on the hook for spousal maintenance, he could say no, the entire amount. But he tried to narrow it down, and the court still rejected him. Why would we affirm that?
Because he failed at the specific evidence. He failed to specifically parse out how much exactly was what. School costs more than tuition.
But if we accept the cases that say that debts incurred during the marriage are presumably community, the burden is on her to parse it out.
Well, I can tell the court from experience that the nearly universal rule is student loans always go to the parent who is forced to incur them. I can tell this court again, since we're looking at
that's universal practice in Superior Court.
Nearly
where's
universal in my
experience.
experience.
That's the law.
And that's why we need some case law at some point. And again, the facts of this case would make for bad case law. They would make for something that just simply can't be construed correctly. Again, we're looking at that goalpost analogy, and the facts of this case just simply don't carry that ball between the goalposts, or this court can't say that it was indeed an abuse of discretion and that it wouldn't clear on that. I would also point out, Judge Morse, you mentioned with respect to spousal maintenance and how this works. Well, the reality is that under 25-319B, if the court had saddled her with a portion of this debt, that would have been a consideration for more spousal maintenance. It would have been completely within her discretion. So this is a big picture. It's a constellation here. And if he gets what he wants in one respect, it's going to impact another part of the order.
So if we, and I'm not saying this is where we're going, I'm just throwing out hypotheticals here. If we were to say that the court erred in allocating community debt, you would say then we would also need to vacate the spousal maintenance award or allow the court to reconsider the amount of spousal maintenance in reallocating the community debt.
If the court follows 25-319B, yes, that necessarily follows. Now, another thing, Judge Morse, you said you had asked Mr. Ellsworth if he were forgiven, if his client were forgiven of this loan eventually, then there could be a reallocation of debt. 25-318 does not allow a modification of a debt division or a property division. It allows it subject to Rule 85/Rule 60 motion, but the allocation is final. I want to point out several things. Let's go back to imputation of income for child support. I don't believe that the court did refuse to impute income. Now, if the court had refused, it would be well within its discretion, but look at what was supplied. There was an original child support worksheet That order was later vacated as a result of a motion to amend. So the original child support worksheet showed an 84-16 division of income, whereas the final order showed a 76-24. Mother's income went up by 8 points in this final worksheet that was used. The only mathematical explanation for that is that the trial court did ultimately impute income. So I don't believe that argument goes anywhere in the record. I want to point out also many cases, many parts of the opening brief and the reply brief where an assertion is made that the court did this, the court did this. Most of the time, or certainly most of the questions that the court asked Mr. Ellsworth were on or around this subject. Typically, when an argument is well-based, when an assertion is made about what the court did, there will then be a citation immediately to the specific findings. And there is no such finding. There is no such finding that this trial court favored mother because she was the primary caretaker, as has been argued under Barron. It's just not there. That gives the court an idea that what we're dealing with simply does not add up legally. Finally,
I think that was based on an inference from other findings, but
it is an
but
inference.
your point is that even if it was inferred, that then at most it would be contested, and then
Absolutely, because again, this court certainly cannot be tasked with mind reading. You can't say, oh, I know the judge made specific findings of why this is in the court's or in the children's best interest, but this is what she really meant. We just can't do that. This court just can't do it. It's not how things work on appeal. Now, with respect to attorney's fees, this is a big deal. It is clear that father is not happy with the ruling, but that does not establish legal error. We notice in particular how his arguments have morphed, how his main argument before, to his credit, he abandons on the reply brief with respect to this presumption of equal parenting time. But when he goes from one to another, and there's hardly anything cited to the record finally, and very little law cited outside of Barron, on which reliance is misplaced, again, it is not a sign of something well taken, and in terms of attorney's fees, in the language of ARS 25324, it's simply not reasonable. This reasonableness is in addition to the dramatic disparity of income. He's a doctor.
Is it really a dramatic disparity of income after we have a spousal maintenance award and a child support award?
They're still close to a 2-to-1 disparity. There's still a significant disparity, and for there being 6 children, we would normally expect closer to an equal division at the end of the day after those support orders. We still don't have that. What that means is he is financially able to continue this litigation a year plus past the trial date, but I can tell you that mother is not. That mother is tasked with taking care of those children, and mother is tasked with supporting herself.
You're talking about reasons for affirming the trial court's order granting it.
I'm also talking about reasons for granting her attorney's fees on appeal, as has been requested.
So, counsel, I just want to ask if your partner here has found where it was acknowledged. I haven't yet. Okay, keep going.
Would the court like some post-trial briefing on that? It would be as simple as a citation.
We're familiar with the record.
Fair enough.
Okay.
We'd be happy to provide that if the court feels like it. No, Judge Morse, you did not abuse your discretion on Adkisson. I can confidently say that. And
I didn't write it, but I fully
You were
agree
part
with
of
it, just like I fully agree with the case at the time.
That makes 2 of us. But that's what I get for being a purist sometimes. But again, the law that we are left with, whether we like it or not from the Supreme Court, is that a hybridization is legally permissible. That's what we have here. But again, I do believe it's important to note that at least with that hybridization, Dad gets a right to judicial review if he disagrees on specific decisions, rather than having to come back for a whole modification and establish a change of circumstance, get over all those hurdles, et cetera. I want to point out, this court already saw it and this court already noted it, that these are credibility determinations, that these are factual weighing issues. where Mr. Ellsworth claims there's no evidence to support it. No, there's simply conflicting evidence. Candidly, I think most of the evidence, the salient facts in this case, are not disputed. There is a lack of evidence in general, as there is on some issues with, for example, the debt division, the student loans. That's just a failure of one party to produce sufficient evidence, and again, that leaves us with some bad facts, and as we learned in law school, bad facts make for bad law. Does the court have any other questions for me?
No, thank you.
I thank you for your time.
Thank you, Mr. Shields.
Sorry, you should have been giving that answer instead of me. I don't know why.
Thank you, counsel, for your arguments. We will take this matter under advisement and issue our decision in due course. The court will recess on the bench so that we can get counsel switched out for our next argument. Thank you. We are in recess.